All right, why don't we get started? I think folks are going to be trickling in. There's a lot of interest in this panel, obviously, but why don't we get started? So greetings, everyone. Welcome to this issue briefing on civil rights and hiring technology in the age of AI. My name is Annetta Bernhardt, and I direct the Technology and Work program here at the UC Berkeley Labor Center. We are co-sponsoring this event with the California Employment Lawyers Association. And I will flag that we are planning this to be an ongoing series exploring issues surrounding new technology in the workplace. A few notes on logistics before we get started. We will be recording this webinar and we will distribute it to registered guests afterwards. If you are legislative staff, if you could please add your office in your Zoom name, you can edit it directly via the participant list. That would be great. And we will have a brief question and answer period after the speakers. But if there are questions that we can't get to, we will be sure to follow up after the event with you. So that said, I would like to turn it over to my great colleague, Ken Wang from the California Employment Lawyers Association.
Good afternoon, everybody. And thank you all for joining this issue briefing today. And thanks, Annetta, for the introduction. My name is Ken Wang, and I'm the Policy Associate with the California Employment Lawyers Association. CELA is a statewide organization of over 1,200 California attorneys who represent employees in individual employment cases and class actions, including cases involving unpaid wages, discrimination, harassment, retaliation, and whistleblowing. So we're here today to talk about civil rights and hiring technology, and specifically increasingly advanced forms of hiring technology that purport to decrease or even eliminate discrimination in hiring. And while our speakers will go in depth to examine the impact of these new tools, what we do know is that hiring discrimination remains stubbornly persistent. Studies have shown little to no progress in hiring discrimination for Black and Latino workers in the last several decades. So as worker advocates and policymakers, it behooves us to continue to confront this disparity, to challenge systemic racism, and to continue to tailor our policies to improve on the status quo. So why are we having this conversation right now? Well, the first reason is that we're beginning to see the light at the end of the tunnel of this pandemic, hopefully, which has had a disproportionate impact on countless low-wage workers, and specifically people of color and women. So how will the coming hiring wave be during the economic recovery be shaped by the adoption of these technologies? And what should be the guiding principles to inform our public policy response to protect workers going forward? And the second reason is that the Me Too movement and the Black Lives Matter movement have pushed companies to address toxic workplace cultures and corporate practices. Now, employers and tech platforms have made efforts to try to answer this call. And part of this effort has led some tech platforms to design and promote tools that purport to reduce or eliminate hiring bias. Now, that all sounds nice, but how do these platforms actually work? How will the adoption of these technologies impact workers? And how can we ensure that employers and vendors are accountable if these tools fall short? So thankfully, we have three distinguished speakers to help answer some of these questions. So first up, we have Lindsay Nacco, who is the Director of Litigation at the Impact Fund. The Impact Fund has represented workers in impact litigation challenging discriminatory employment practices for over 25 years. They also provide strategic leadership and support for litigation to achieve economic and social justice. Next up, we have Aaron Reike, who is the Managing Director of Upturn. Upturn advances equity and justice in the design, governance, and use of technology. Their research and advocacy combines technical fluency and creative policy thinking to confront patterns of inequity, especially those rooted in race and poverty. And finally, we have Matt Schur and Riddhi Shetty, who are both policy counsel at Center for Democracy and Technology. The center works to promote democratic values by shaping technology policy and architecture with a focus on the rights of the individual. So before I turn it over to speakers, we do have a Q&A function with a Zoom webinar. So if you have questions as the panelists are speaking, feel free to type in your questions then, and we'll try to get to it in the Q&A segment. And as Aneta said, if we can't get to your question, I'll be sure to follow up after the webinar. So without further ado, I'll turn it over to Lindsay.
Great. Thank you so much, Ken, for inviting me today. And thank you to everyone for joining us to talk about this really important issue. As Ken mentioned, I'm Lindsay Nacco, the Director of Litigation for the Impact Fund, and I have spent the last 15 years representing workers in class action and individual litigation, many of them alleging discrimination in violation of Title VII and California's Fair Employment and Housing Act. Hiring discrimination cases are relatively rare for a simple reason. Workers who are denied employment generally do not assume that they've been discriminated against. Their first instinct is not to sue a business with whom they had limited contact or for whom they wish to work one day. But maybe they read an article in the paper, or they see that the business's employees appear limited to a particular demographic, and they take that extra step of reaching out to an attorney. These few denied applicants will still face an uphill battle in proving discrimination, one made potentially steeper by algorithm-based assessments involved in the hiring process. So many hiring discrimination cases challenge hiring assessments, whether they are cognitive tests or physical ability tests, personality tests, or other kinds of tests. Hiring assessments are not new, nor are they problematic in principle. They become problematic and potentially illegal if they exclude applicants with protected characteristics from the hiring process more often than other applicants. If they're more likely to push applicants of color out of the process than white applicants, women more so than men, older applicants more so than younger ones. Maybe the employer intends that outcome, or maybe not. They risk violating the law either way. Applicants carry the burden of demonstrating that the hiring assessment has discriminatory results. After the lawsuit's filed, the applicant and the employer will exchange information, and an employer is generally required to share the results of its hiring process. This data is analyzed by a statistician hired by the applicants and paid for by the applicants to determine if people in the protected group, whether people of color, women, applicants with disabilities, or others, are in fact disadvantaged in the hiring process. And doing so is an expensive process of analyzing hiring data to determine who is excluded from the process, when, if it's a multi-stage hiring process, and why. The legal rules governing hiring assessments were set by the EEOC over 40 years ago in the Uniform Guidelines on Employee Selection Procedures, which were also adopted by California's Fair Employment and Housing Council and incorporated into the California Code of Regulations. The Uniform Guidelines set specific requirements for employers using hiring tests, including with regard to test validation and record keeping. I'd like to take a moment and talk a bit about test validation. Here, validity means whether the hiring test accurately assesses the precise qualities that the employer is trying to isolate and evaluate. If there's no evidence of adverse impact, validation is not required, meaning if there's no indication that applicants with protected characteristics are being excluded more often, employers are not required to validate their hiring assessments. That said, the Uniform Guidelines strongly encourage employers to use valid selection procedures. And a truly valid selection assessment is evaluated in the workplace where it is going to be used and calibrated to the job for which the employer is hiring or the particular criteria that the employer is seeking. And also, if the hiring test does in fact have adverse impacts on applicants of a protected group, the Uniform Guidelines require that that test be presumed discriminatory unless the procedure has been properly validated. So even though validation isn't explicitly required under the Uniform Guidelines, it is certainly encouraged and is one clear way for employers to protect themselves from legal liability. But it's not enough to just validate an assessment one time and then use a test for years or in any context. Assessments must be revalidated when the previous results are no longer current, when they become outdated or they change, or if they're put to a different use. Employers are ultimately responsible for ensuring the validity of their tests. The guidelines require that under no circumstances will the general reputation of a test or other selection procedures, its author, publisher, or casual reports of validity be accepted in lieu of evidence of validity. And just a quick note on record keeping, the uniform guidelines state that employers should maintain and have available for inspection records or data that show the impact of hiring assessments on employment opportunities for applicants of different protected characteristics. If there is an overall adverse impact and there are multiple components to a hiring process, data must exist to evaluate each individual step of that process for adverse impact. So this is the current framework for evaluating hiring assessments. It's relatively robust, and it's been applied by courts in cases across the country for the last 4 decades. It relies on actual outcomes and test validation to ensure equal opportunity for all applicants and requires record keeping to provide transparency. So what happens when the old personality or cognitive test gets replaced by an algorithm, usually in the form of a product purchased by the employer from a third party that puts applicants through a video interview or a video game assessment or an automated resume screening, with the goal of producing a list of qualified, in quotes, candidates for the employer's consideration. Well, at a minimum today, under the uniform guidelines, applicants are entitled to access records or other data to show the impact of that algorithm-based hiring assessment on protected groups. So they need to be able to access the actual outcomes of the hiring process. That assessment should be validated in the workplace and for the job for which it is being used. If the assessment excludes applicants at various points, each step must be able to be analyzed separately for adverse impact. And that assessment must be revalidated in the workplace and for the job every time the last validation is no longer current, which means every time the algorithm undergoes a relevant update or is used for a new purpose. And finally, the employer remains responsible for ensuring the assessment is non-discriminatory and valid, no matter what promises have been made by the company that created that product. These basic protections are more important than ever to ensure equal opportunity for job applicants in the digital age. There is no obvious reason to lower these requirements for algorithm-based assessments or to create new protections for employers just because they have used algorithm-based assessments. As Erin will explain, the claim that algorithms are less biased than human decision makers requires close scrutiny. Bias may come from unexpected places, but it certainly continues to exist. For example, attempting to recreate certain aspects of an employer's current workforce, whether productivity, trustworthiness, may also recreate certain other aspects of the current workforce, such as its demographics with regard to race or age or gender. Or employers may not know where the disparities originate in an algorithm-based assessment created by a third party. The company that created the product may not precisely know which part of the algorithm pushes women or people with disabilities down in the rankings. It may not be able to isolate where in the product an individual applicant was excluded, denying applicants the ability to challenge individual discriminatory steps in a multi-step process. Even assuming that algorithm-based assessments are better than human decision makers, that does not prevent employers from using these assessments incorrectly. For example, setting an arbitrary cutoff for the number of people it wishes to interview, rather than setting it to the number of people who are deemed qualified for the position, or using it for a purpose other than that for which it was validated. In Connecticut v. Teal, the Supreme Court stated that the principal focus of Title VII is the protection of the individual employee. Each individual applicant is entitled to the protection of Title VII and the Fair Employment and Housing Act to be assessed fairly on their individual merit, to be given equal opportunity to succeed. To make the promise of our anti-discrimination laws real, To ensure transparency and accountability, job applicants must have ready access to information and data about how and what happened in the hiring process, and employers must be able to explain how their employment decisions were made. Thanks so much. And with that, I'll pass it on to Aaron.
Great, thank you, Lindsay. I'm going to share my screen here. I'm here today to talk to you about how does this technology work? And in more concrete terms, what do we mean when we say that new technologies can discriminate? I'm going to show you some pictures. I'm going to tell you a few stories. This is going to be less of a textbook and more of a storytelling exercise to kind of give you the gist of what's going on. One thing Lindsay started with that I want you to keep in mind is if you were a job seeker, I want you to be thinking in the back of your mind as I talk through these examples. If you were a job seeker, how the heck would you know that any of the things I'm going to talk about were going wrong? Because I think that's a huge, huge difficulty for accountability here, is there's just no visibility to the individual applicants, which is candidly what lawyers need a lot of the time to do their work. So the picture you see right here is the hiring funnel. Lindsay also emphasized steps, right? I want to double emphasize steps. There's a lot of steps in the hiring process. You have to learn about a job. Somehow you're screened, you're interviewed, there's a selection process. And then when you're on the job, you're evaluated. And all these steps are connected, and technology can change how things work at each one of these steps. And so I'm going to use my 10 minutes to tell you 3 stories, one at each step. And hopefully through these stories, you'll get an intuition for how the new technology is working and the ways it can go wrong. The first story I want to tell you takes place at the sourcing stage. This is when you're an employer and you're trying to get people to apply for your job in the first place. You don't have applicants yet. Let's imagine that there's a global pandemic and you've got a few kids and you want to hire a care worker to come do a nanny share in your home. And you think, maybe I'll put an advertisement out on Facebook. And by the way, this story is based on empirical research. I'll put my email address up at the end if you want all the citations for the things I'm going to talk about today. So we make this ad. It's a perfectly good ad. It's inclusive. The language is great. We go to Facebook and we say, okay, we're going to choose a target audience for our ad. And we want to include everybody in the United States between the ages of 18 and 65. That's about as inclusive as we can get. We're not doing anything wrong at the targeting stage. So we've got about 100 million people in the country that could see our care worker ad. Now, here's where technology comes in a way that may not be obvious to you. Everything we've done so far looks great. When you scroll down your Facebook feed, about 1 out of every 5 slots is a spot for an advertisement, okay? Every time you hit an advertisement slot, there's a little auction that goes on in the background. And that auction gathers all the ads you're eligible to see and chooses the one that Facebook wants to put in front of you. So imagine someone is scrolling down their Facebook feed and there's our care worker ad, a toothbrush ad, and a jewelry ad that they could see at that moment in time. How is Facebook going to decide which ad to put up in front of them? One question is, well, how much is the advertiser willing to pay? But the less obvious question is, how likely does Facebook think that that person will click on the ad, considering everything Facebook knows about them? So I'm going to fast forward to the end of this story. This is the audience demographics of the folks that saw the care worker ad in this experiment. Predominantly women between the ages of 25 and 45, virtually no men. And none of this is based off of an intent that I expressed as an advertiser. This is all based off of Facebook's analysis of who do we believe the right people are to see this ad. And you can imagine the way that computer programming positions, taxi driver positions, all of the biases that you would associate with the workforce demographics of those fields are automatically reflected by these technology-rich platforms that show people advertisements and job listings. So that's the end of story 1, right? I just want you to have an initial sense that even before people even apply to a job, the funnel starts to narrow and technology plays a role there. Story number 2, let's go down to the screening stage. A bunch of people have applied for a job. And the story I want to tell you here comes from a reporter in courts. Dave here, the title of the story is "Companies Are on the Hook If Their Hiring Algorithms Are Biased." But I want to tell you the story from this piece because it is the best single example I've ever seen of bias arising from hiring technologies. there was an employer and they said, we're getting a lot of applicants and we want a model, a statistical model that will evaluate the resumes that we get and help highlight the strongest ones. Okay. So here's what the vendor did. The vendor said to the employer, that's great. Why don't you just show us a sampling of the resumes from your strongest employees over the past 5 years or so? So the employer says, sure, here's our best people. Here's their resumes. Using those resumes, the hiring technology vendor built a model automatically and said, well, here we have a model that's learned the common elements from your strongest employees as demonstrated from their resumes. Now, the model learned that there were two things that were highly predictive of job performance based on that resume set. The first rule was, is the person named Jared? If so, we've got a strong sense they might be a good fit. The second criteria was, has this person played high school lacrosse? Okay. Now, this was correlational evidence, right? And I think what this clearly suggests is that you have a culturally homogeneous workforce, and machine learning and technology is very good at picking that up. Back to Lindsay's question, is this validity? Heck no. No. Being named Jared and playing high school lacrosse have nothing to do with someone's ability to perform at this job. But this is what artificial intelligence and machine learning is very good at, is spotting patterns in historical data, right? Women tend to click on the caretaker ads. High school lacrosse playing Jareds have been successful at your company over the last 5-year period. That's you're starting to see, right? That's the common theme, the way the patterns arise when you use data sets. All right, last one, and then I'll wrap up and throw it over to CDT for all the answers. At the interview stage, right? You've probably seen a bunch of stuff. Here's a little bit of advertising from a company called Elevate, and they claim that they can assess personality and job suitability from a 30-second video. And there's a guy, doing his 30-second video, and you can see he's been rated on his openness, his adventurousness, his sensitivity, whether or not he's a change agent. I choose this example because it's easy and ridiculous. Like, you don't have to be an industrial organizational psychologist or an AI expert to realize that this is ridiculous, right? This is merely another big correlational machine. And it's making claims that I think are highly, highly suspect, right? And so I'm not going to dwell too much more on this because I don't think I need to. I think it kind of speaks for itself. The thread I want to pull together from these three stories is what new technologies, and by that I really mean machine learning, right? Learning from patterns in large data sets. That has its own inherent risks in a world where there's a ton of inequality and injustice in our history, and how that's reflected in our workforce. So let me give you a few reflections and a few questions that you as policymakers can ask as different companies come talk to you. Review, right? Hiring's not a single decision point, but a series of smaller sequential decisions. Don't get too fixated on any one particular tool or any one particular stage, right? These are challenges all through the process, beginning to end. Even before people apply for jobs, that funnel starts to narrow. As policymakers who think about hiring and employment justice, don't forget about the LinkedIns and the Facebooks and the ZipRecruiters of the world. That stage matters a lot, and there's just too little scrutiny there right now. Hiring assessment technologies rarely make affirmative hiring decisions. You'll hear that a lot from these technology companies, and that's true. But these tools do automate rejections, and they exert a huge influence on the hiring process by ranking applicants, right? So even though it is true, the tool isn't making the final decision, they're still really important. 3 reflections, and I'll be done in 2 minutes here. As Ken said at the beginning, I don't want to underplay the fact that we know from decades of audit studies that employers tend to discriminate against women and ethnic minorities, right? This is not getting better. So the premise that you're going to hear from hiring technology companies that humans are biased is true, right? Don't dispute that. However, think back to these stories, right? Hiring technologies may help avoid interpersonal human biases, but they can embed their own kinds of biases, and at a great scale. Right? It is a different kind of bias, but it is equally dangerous and potentially more dangerous if this scales out to everybody, right? If that Jared high school lacrosse playing resume model went into production and screened thousands of people, that'd be much worse than one racist HR person. So they're not a silver bullet. the last thing I want to say here at the end of my time is, what about debiasing, right? A lot of these hiring technology companies are going to tell you that they debias their products. This is interesting and exciting, but there's far too little is publicly known for us to put our eggs in this basket yet, right? As Lindsay said, responsible employers and technology vendors should be looking at the outcomes step by step, analyzing those outcomes for adverse impacts and making adjustments. There are some exciting things that technology can do to help make that measurement process easier, and then to help make adjustments that are sensible, right? And so I don't want you to completely ignore these claims of debiasing, but I want you to ask them for all the details, right? And by the way, this is not something that should be special to hiring technologies. This should happen for all hiring tools. So the ending message is all hiring tools, old and new, should be considered on their old merits. I'm not here to tell you algorithms are worse than people or people are worse than algorithms, but I am here to tell you that algorithms are not a silver bullet. And this is my email address, aaron@upturn.org. I covered a lot here. If you are interested in learning more about any of these individual stories, seeing some of the empirical evidence behind the things I discussed, or hear this in more than 10 minutes, feel free to send me a note. And with that, I'll turn it over to CDT.
All right. Thank you, Aaron. And I am going to head and share my screen as well. Just one moment here. I apologize. Tech is deciding whether or not to let me share my screen on this. All right. I apologize. I am unable to share my screen at this time.
Can you try it again? I think Ken just made you co-host.
Unfortunately, that's not the issue. It's that I will have to quit and reopen Zoom in order to share my screen. Let this be a lesson. Never switch from Windows to Mac right before you give a presentation in front of 100 people.
If either of you have a link and put it in chat, I'll pop up and follow along with you as you.
That would be great. I'm going to send you that link right now.
Yeah. All right. You can kick off. I'll get this up in just a sec.
All right. So, hi everyone. My name is Matt Scherer. I am with the Center for Democracy and Technology. I'm Senior Policy Counsel for Worker Privacy there. Riddhi, do you want to introduce yourself as well?
Hi everyone, my name is Riddhi Shetty and I'm a Policy Counsel on the Privacy and Data Project at the Center for Democracy and Technology.
All right. So it looks like we have the slides up. Thank you very much, Aaron. So first, just briefly, some background on the civil rights principles. As you've heard a little bit about today, entities are increasingly relying on tech-based solutions for their hiring needs. And really, that's true of everything. And companies are increasingly looking to tech and artificial intelligence to help improve their operations. Combine that with the perception that human resources in the hiring process is purely a cost rather than an asset, because HR never generates revenue for an organization. And what you end up with is hiring tech becoming much more prevalent. And this led to concerns about algorithmic bias, because we've seen that crop up in so many other areas. So a coalition led by the Leadership Conference on Civil Rights and the Urban Institute, and including both CDT and Upturn, started looking at this issue and decided that even well-intentioned tools warrant some skepticism. And one of the fundamental takeaways that these organizations had was that employers should share responsibility with vendors and they can't just be passive consumers of technology. And responsibility has to fall on both employers and vendors to ensure that tools are fair and unbiased. So CDT and Upturn joined numerous advocates in the civil rights, workers' rights, and tech info policy world to weigh in on these principles. And as you can see, the organizations that ended up co-signing the principles and helping develop them are a veritable who's who of major civil rights organizations in the United States. And this reflects the fact that tech-driven decision-making, particularly in something as crucial as somebody's livelihood and career, that makes this one of the great civil rights issues of our times. And we need to stay ahead of the laws and regulations in this space.
So this coalition's efforts resulted in a total of 5 principles. The first is non-discrimination. Tools should not deprive a person of their access to employment or compromise their access to employment on the basis that they belong to a protected class. So as you heard earlier, these tools are often trained on data that's derived from an employer's existing workforce. The tools can reproduce biases in employers' hiring practices, and if these biases are left unscrutinized, these tools can in turn reproduce and reinforce systemic discrimination in the employer's hiring practices. So the tools must be designed for fairness. And so they have to be developed at the front end to ensure accessibility and minimize racial and gender discrimination, but also discrimination on the basis of disability, age, and other protected groups. And different types of discrimination require distinct design considerations and approaches to testing. So non-discrimination calls for a more proactive and ongoing effort to avoid all discrimination. It also includes being thoughtful about how reasonable accommodations will serve people with different disabilities and different presentations of the same disability.
Right. And so the next principle is job relatedness. And the idea here is that hiring assessment technologies should be designed to measure people's ability to perform the jobs for which they apply. And I don't want to belabor this point too much because Lindsay actually covered this in pretty good detail in her presentation. The idea is, though, that employers have to start by inventorying the skills and qualifications that are needed for each job, and then train and tune the tool to those attributes rather than to potentially relevant material. And particularly pertinent here, you don't want to train it to whatever attributes current employees happen to possess. And you don't want to train it to generic personality traits or other non-job specific attributes. And these possibilities are what really makes job relatedness a civil rights principle. If you simply train a tool to reproduce the traits of your current workforce, you're reinforcing any existing biases that currently exist there. And for generic personality traits, trying to measure things like reliability, risk appetite, enthusiasm, you end up including things that may have no bearing on the specific job at issue, may reintroduce and reinforce structural forms of bias. And really, they could end up essentially just being a test of how normal someone is, rather than how good they will be at performing the job at issue. And to that end, it's important that validity be tested separately for each employer and for each job at that employer for which it will be used. And as I said, you heard Lindsay go over in very good detail the reasons for that and the current legal standards that govern that.
Next principle is notice and explanation. This applies both before an applicant is evaluated and after a hiring decision is rendered. So applicants must know before their evaluation what the tools will measure, how they will have to engage with the tools, including the kind of equipment they may have to interact with, and what they will have to do in order to use the tools, what reasonable accommodations are available, and how they can access those accommodations. And so employers need to make sure not only to explain this ahead of time, but also after an adverse hiring decision is rendered, they should explain to applicants how the tools arrived at that decision. So notice and explanation end up being another important tool to help people exercise their civil rights. One problem here, though, is that without an appropriate accountability mechanism in place, employers don't really have much incentive to give applicants explanation, because they'd essentially be giving applicants information that would make it easier for applicants to gauge whether the tools were biased and whether they were subject to discrimination, so that they can therefore exercise their rights by filing a claim.
And the next principle is auditing. Employers have an ongoing obligation to effectively audit hiring assessment technologies. And by effectively audit them, that means just not doing what's easy and convenient. Using statistical tests, adverse impact analyses, that's convenient. It's relatively easy to conduct those if you have the data available. But no single test can spot all possible sources of bias. Employers and vendors need to be required to proactively analyze tools for potentially discriminatory design elements, and then follow up regularly to capture changes in jobs and in the workforce. And as Aaron went over in his presentation, the audit results should be made available to the public for examination, accompanied by next steps for correcting potential and actual problems. If companies are told you have to conduct bias audits, but there's no obligation to make those results public, then a lot of the times applicants, number one, might not even have any idea that a tool is being used, much less have an inkling of what sorts of biases could be affecting their ability to be considered and accepted for the job for which they've applied.
And finally, we have oversight and accountability. So guidance and technical standards have to evolve to keep up with advancing technologies. One common source of guidance comes from the Uniform Guidelines for Employee Selection Procedures. So as Lindsay described earlier, in terms of being instructive, these guidelines were issued in 1978, so they're outdated, and they technically do not apply to disability and age discrimination. And they also rely on methods like the 4/5 rule, which essentially states that the selection rate for people belonging to a protected class must be at least 80% or 4/5 of the selection rate for people who do not belong to that protected class. Rules like this will not apply accurately to discrimination such as disability discrimination, because you'd have to measure not only disability as a whole, but all the different types of disability and the different presentations of disability, which is a lot harder to quantify. Such outdated guidance ends up causing a lack of clarity and leaves a lot of room for interpretation that allows employers and vendors to get away with not complying with their existing legal obligations. So in addition to having information about the tools through notice and explanation, applicants need to be protected by an effective oversight from the government that can keep up with the new technologies to hold them accountable.
So in conclusion, as was mentioned before, and as you saw from the list of signatories, these principles represent the strong consensus of civil rights organizations in the United States. And each of these principles was something that the signatories agreed was essential to ensuring that hiring assessment technology is used in a way that doesn't set back the cause of justice and equity in the labor market. The principles are not simply a menu to choose from. An equitable tool upholds all of the principles. And the principles must apply to the entire life cycle of the tool, starting with design, going through implementation, and then during the time that the tool is deployed, including auditing. These sorts of tools can and should expand employment opportunities rather than limit them. A tool that truly reduces bias is going to identify applicants that otherwise would be rejected because of a recruiter or an interviewer's bias. It's not going to limit the playing field and exclude people from the hiring process. And one last wrap up. Thank you, Aaron. You get the Chris Paul Award for the biggest assist during this presentation today.
So thank you to our speakers. I know I learned a lot from, and it's a very kind of information dense presentation, but I think it really lays out nicely kind of the dilemma that we have on our hands between the claims that are being made versus what the actual technology does and what we're striving towards. So thank you so much for your presentation. And I would encourage participants to type in the Q&A with any questions that you may have coming out of those presentations. So I wanted to start off the Q&A section with a question that posed by one of our participants, which is that what is the interplay of responsibilities currently between a vendor and an employer, should they kind of decide to adopt this kind of technology. And so who is responsible for auditing? Who is ultimately responsible for the discrimination? How does that work under current law? And how should it work, should we decide to regulate?
So ultimately, right now, employers are the entity that is ultimately responsible for discrimination. Most, certainly at the federal level, all anti-discrimination laws, they apply to a certain limited class of people and entities, namely employers, sometimes employment agencies, labor organizations. And in California, the laws are written pretty much the same way. So ultimate responsibility for this falls on the employer. They are the ones that currently have the obligation to ensure that the tools that they use are not discriminatory, which is a good thing, because in a sense, we want the employer, the person that's ultimately, the entity that's ultimately going to be making the hiring decision, to feel that sense of responsibility. What's unfortunate is that they often are at a disadvantage in terms of knowing how these tools operate. A lot of the times these tools are proprietary, and vendors are not willing to share key aspects of how they work. And even when they do, often collecting the data necessary to conduct an effective bias audit isn't readily available. And employers are just feeling such pressure right now because of all the hype surrounding AI, and the fact that there's just a lot of organizations are using these tools and are hyping them up. And there's kind of this fear of being left out if they are too late to the ball game in adopting them. So while it's a good thing that employers are on the hook, they aren't always in the best position to be able to ensure that these tools are fair and non-discriminatory. And policy should reflect that fact and should put pressure on both vendors and employers.
Yeah, I think that's exactly right. I just want to add one thing to what Matt said, which is just to emphasize, all the legal obligations are on the employer. But also the vendors are often best positioned to do the analysis in some cases together with the employer, right? And a lot of hiring technology companies in particular keep their own sets of demographic data and results for everyone that goes through their tests, right? And so there's like two sources of people that can do auditing, the employer and the vendor. And as Matt said, I just think that like any new good modern policy here would address both of those parties and compel them both to be working on this and being transparent.
And one practical note to add into that, I completely agree with everything that everyone said. And while employers hold the ultimate liability for their hiring decisions, I expect that practically speaking, we will see some finger pointing in court where employers say, I thought I was doing the right thing. I bought this product. They're the ones who can tell you how it worked. And while, like we talked about under the uniform guidelines, a promise of non-discriminatory validity doesn't actually insulate the employer, I expect will be then, as plaintiffs, having to go through a third-party subpoena or some other mechanism to then have to go to the purveyor of that product and say, okay, you need to show us how this works. And I will guess that they will not happily and voluntarily hand over the kind of data that employers are today obligated to have. And I expect that even we'll be needing much more information than the base minimum that the uniform guidelines currently require in terms of just the outcomes. We'll need to see many layers of how a decision is made to actually enforce the rights that people have under Title VII and FEHA.
And just really quickly, if I could riff on one point that Lindsay alluded to. So we've been talking, for the most part, when we've been talking about discrimination, we've implicitly been talking about disparate impact discrimination. But it's also actually possible that these tools could engage in disparate treatment. That is, that behind the scenes, they could be taking into account the actual protected characteristics, either explicitly or because the vendor didn't do a good enough job censoring that information when building their model. So, and part of the reason that raises an issue is that a lot of the case law around disparate treatment speaks in terms of intentional discrimination. So an employer, it's not clear what would happen under current legal standards. I certainly have my opinion on what should happen, but it's not actually clear under current legal standards what happens when an employer kind of unintentionally adopts a tool that actually engages in direct discrimination against people on the basis of protected characteristics. So that's another reason why there needs to kind of be a treading carefully when adopting new policies that place responsibility for ensuring that these technologies are fair and non-discriminatory.
Thank you for those answers. We got time for maybe one or two more questions. And there's a question out here asking whether there are any examples of laws right now doing a good job regulating in this area. So an example is cited about the GDPR. So can folks think of any good examples?
Illinois. Oh,
Go ahead.
I was going to say Illinois has been out front on regulation of the use of algorithms in various contexts. Right now, they are, I believe, the only state that has a law in this area. And what it requires is only that people be notified if the hiring process that they undergo is going to involve artificial intelligence. And so that's not even really governing what the outcome is, but it's just going to the notice point that Reedy and Matthew referenced in their presentation.
Yeah, I think, the GDPR is hard. It's a powerful law in theory, but it's so high level that I think in practice, we haven't seen tons of good results here yet. One thing I just want to point out back to Lindsay's very first remarks is that one of the big challenges here is that the regulators kind of are stuck in the position of waiting for people to complain, right? And no one is seeing stuff that allows them to complain well. And so I think that, like, as a model, you might look to some of the auditing requirements that are placed on federal contractors who have to submit data and audit reports proactively to a regulatory authority. And even at a state level, one can imagine a regime as a starting step, where employers and vendors together would have to produce some sort of public evidence and audit reports, not that guaranteed them compliance, but just so that information was on the table, right? For you to see as policymakers, for us to see as advocates, for applicants to see and understand. So I think as a very, very first step here, I would be thinking towards what kinds of new transparency, both with respect to audits and for applicants, can we be thinking about?
So do others want to build on that point? Is if we're considering a first cut at trying to tackle this problem, and of course, when we're talking about the impact of algorithm and the workforce, it extends far beyond kind of hiring. It goes into algorithmic management and all steps of the employment-based decision-making of an employer. What are some suggestions for the first cut in terms of policy interventions that we can consider making?
So as Lindsay noted, the only thing we've seen so far is in Illinois, and it's worth noting that even under the Illinois statute, there's no penalty or enforcement provision built into it. So even the kind of rather timid notice requirement that it provides doesn't actually have any teeth to it. So the first step is to actually make sure that whatever bill gets put into the world actually has penalty and enforcement provisions. One idea would be to not necessarily, create an entire new regulatory regime to it, but simply kind of layer on to the existing laws against non-discrimination, additional penalties, enforcement, and auditing provisions, so that when when an entity is found liable for discrimination, there is, number one, shared liability between the vendor and the employer. That way, both of them feel the heat on it when an automated tool results in discrimination. Joint and several liability between the vendor and employer would basically force both parties to take a hard look at their technology. And the second would be requiring an audit. And if you don't do that audit, or if you do that audit and it reveals some sort of evidence of discrimination that an employer or vendor ignores while pressing ahead anyway, enhancing the damages that are available if there's a successful discrimination lawsuit brought. So saying, there are some statutes where this already exists, not in the employment discrimination case, but where you have double or treble damages if you kind of know that you are pressing ahead with a technology that either hasn't been vetted or that has been vetted and you have seen problems that you've chosen to disregard and press ahead with anyway. So those are some ways that you could get to that issue without necessarily establishing a completely comprehensive regulatory regime that is specific to automated tools, but you simply kind of shift the responsibility to where it needs to be under existing discrimination laws.
Yeah, and the last thing I want to say that Matt ended with that I think is important personally is just be wary of creating laws that target quote unquote hiring technologies specifically, right? Like it's a definitional impossibility. And like there's a lot of bad tools that are traditional tools too, right? Like if you go and apply to CVS online today, you're going to take a 98 question personality test. Right? And that gives me equal amounts of heartburn when it comes to bias and discrimination. And so like, I think just resisting in general, this idea that we need to address technology as special. And as Matt said, think about ways to enhance the strength and the modernity of the whole regime is the way to go.
And my last word on this would be to think carefully about where burdens sit in terms of who's required to make what kinds of showings, and that burdens should sit with the people who actually possess the information. And in this scenario where we have job applicants, we have employers, and we have technology companies, employees have the least amount of information. Job applicants have the least amount of information. And so having the requirements of reporting, transparency be placed more so on the entities that have the information. So technology companies are going to have the most information here, employers secondly most, and applicants are going to have absolutely the least. And so I think taking that into account is also going to be really critical looking forward.
So I think, sorry, Riddy, go ahead. Yes.
That one last point, which is that when you're thinking about discrimination, there's often a default to Title VII, and while of course that has to be a consideration, Title VII is not the only civil rights law that needs to be applied when you're thinking about employment discrimination. So think about the Americans with Disabilities Act, the Age Discrimination and Employment Act. There are not only multiple kinds of discrimination, but also multiple axes along which this can occur. So if you are only thinking about certain types of bias, you can end up leaving out a lot of people that you were initially trying to serve in the first place with the way that you've drafted legislation.
So with that, we are 3 minutes until the end. I'd like to just really deeply thank our panelists for taking the time to come speak with us on this really important and timely subject, and really all the participants for taking your lunch hour to come explore this sometimes maybe very dense and feels very theoretical issue, but is really having a real life impact on many workers today. I also wanted to put up the contact information for all the panelists and the co-hosts. Hopefully you can see this. For today's presentation, and really encourage, if we didn't get a chance to get to your questions today, to email me, ken@cela.org, with follow-up, and we would love to connect you with experts on this panel and also all the signatories to the civil rights principles to really think deeply about how to address this problem.